Monday. It is Bishop on Air and testing out the stream with a couple of different things. I'm still doing some engineering, so we'll have to see how well this works. Let's check to see if I kill the music there, if we get a little bit better of a stream quality. If you guys can just double check and make sure that this stream is not too chunky as we broadcast live. So be sure to let me know how it looks, and we'll see what we can do to make the various tweaks that we need to make. Happy Monday. Good morning, David. Two-Tone on X. Hey, I guess that's big shout out there. Happy Monday. Good morning, Tom, Dave, Tenebris, and Peter, Christopher as well. Happy Monday. Please do let me know if the stream looks a little chunky, and I'm going to just test a few things here just to make sure that we don't get too much overloaded here, but I'm hoping that it sounds good, not too much low or highs. Okay, the sound's good, but what about the video quality? I want to make sure the video quality looks good. Audio and video stable. All right, what if I do this? I'm just going to play a little music, all right? Video glitchy. All right. Little chop. All right, we're getting a little bit of feedback there. Okay, good. Well, I'll have to continue doing some ongoing engineering to make sure that all the different devices I've got hooked up are doing what they need to do. So I might have to actually just have a separate computer to do the live streaming so that we don't get too clunky here. All right, so tons to get to here with Bishop on Air. Greatly appreciate you guys taking the time and tuning in. We've got a lot to get to with the litigation against Illinois' gun and magazine ban. We've got, of course, last week, a lot of things happening with the U.S. Supreme Court denying to take up the case that Dan Calkins brought, and also the case that was brought out of Naperville. So that very much is something that is of concern for a lot of people. But we also have some of the latest out of the district court in the Southern District of Illinois with the Langley case, if you recall. That's the case where Thomas Magg was bringing a challenge on the vagueness issues. Well, Stephen McGlynn denied that partial summary judgment on the 14th. So we'll take a look at some of that. Plus, we'll hear from Chicago reporter William Kelly about the latest on the ground in Chicago. So that is on the way here with Bishop.
The reality is that most people really do understand these rules. And by the way, people are actually signing up, registering their automatic assault weapons, their high capacity magazines rather. And as we get closer to it, we're seeing more and more people actually do what they're required to do under the law.
One thing we see across the board is that the people who are banning them rarely understand the basic mechanics of the guns and the magazines that they're banning. The more they talk about it, the more they betray a very woeful ignorance about the Second Amendment and about the actual arms that are in question. We see that on both the state level and the federal level. You can get a few real laughs sometimes listening to what congressmen say in some of these gun control hearings that they have from time to time on the Hill.
That's Hannah Hill right after Governor J.B. Pritzker talking about registering fully automatic firearms and high-speed, high-capacity magazines. Welcome back. It is Bishop on Air, and this Monday morning after last week, some things happening with the courts, especially the U.S. Supreme Court denying the Naperville plaintiffs' motion to intervene, to have an emergency injunction put into place. So we've got a couple of different things that have happened there, and I wanted to share with you a conversation I had with Hannah Hill from the National Association for Gun Rights, and she provided some reaction on Friday when I chatted with her about what this means moving forward.
So honestly, the news that we got yesterday in terms of the underlying case against the Illinois assault weapons ban is not as discouraging as it felt like to all of us, although I mean, it unfortunately does not block the law for the citizens of Illinois. That's the heartbreaking part of it. And that's what the emergency appeal was about. It was about trying to stop this law from imposing any further tyranny on the law-abiding citizens of Illinois. It's very, very unfortunate that the Supreme Court did not listen when we said that a right delayed is a right denied. But that decision's been taken out of our hands. Applying for emergency relief is always a Hail Mary. We've done that twice on this case, as the Second Circuit first dragged their feet about saying, this is an unconstitutional law, and then came right out and ruled that AR-15s are not actually guns for purposes of the Second Amendment. So we were hopeful when the Seventh Circuit said, no, we're not going to rehear that case, that the Supreme Court would be a little bit more interested in stepping in. And frankly, that actually may be the case. That is what we are hoping. Because from the Supreme Court's perspective, they would rather step in on the actual case itself, whereas if they had granted the emergency relief, it would have done nothing to overturn that outrageous Seventh Circuit ruling, right? It would have been an emergency stay. That's all it would have been for that law. We might not even have gotten a ruling. It could have been just a one-sentence order. And while that would have provided relief, very, very important relief for the citizens of Illinois, it would not have done anything on the main actual case. Besides, we all knew the reality is that the Supreme Court rarely gives that kind of emergency relief. We've only seen it a handful of times. And certainly they've not done it on Second Amendment cases. Every time somebody has asked them to do it, almost every time someone's asked them to do it on a gun case since Bruin, they've said no, and they've indicated over and over again that what we want to do is wait until you bring us the actual case, the lower court process is finished, and then we'll weigh in. So the good news is we know the court's interested, because twice now, Amy Coney Barrett has asked for a briefing from Illinois. When we've asked her for emergency relief, instead of saying no, she turns to Illinois and to the city of Naperville, who's also a defendant on our case, and goes, all right, so tell me why I shouldn't do this. Tell me why I shouldn't block your laws. And so they did, and they gave some pretty nonsensical arguments. Then she referred that to the entire court both times, and it was a joint decision from the entire court. But the thing that happened this time was the Seventh Circuit said, no, we're not going to rehear the case en banc. We are not going to reconsider that panel ruling that said that AR-15s aren't guns for the purposes of the Second Amendment. That ruling makes a mockery of both Heller and Bruin, two Supreme Court precedents that they just outright defied. I am very hard-pressed to think that the justices are going to take that sitting down. And that may be actually why they said no, because they know that we are going to be bringing it back on cert, asking them to overrule that very ruling. We know they're interested. We know they're watching. And we're very hopeful that when we do bring it back and file for our cert petition, which is due the second week of March, that we'll get a different answer from them. Because again, they have to decide if they really meant what they said in Bruin, and frankly, what they really said in Heller. After Heller, they saw lower courts trample it time after time after time. Routinely, they pretend that Heller didn't happen. And the whole point of Bruin was to say, oh no, we actually really meant it. You know how they reestablished that text, history, and tradition standard in Bruin? That wasn't a new standard. It was first laid out in Heller. And anybody who reads Bruin comes away with a very clear distinction that the court was trying to say, we meant what we said when we gave you Heller, and we actually do mean for you to follow that in your rulings. But if they don't want a repeat of what happened 10 years ago with Heller, it's going to take taking some cases like ours before the lower courts get the idea that, oh, no, we actually do have to apply what the Supreme Court said this time. We actually do have to follow Bruin. So it's going to be really up to the court just how much of this lower court defiance they're willing to put up with.
So again, sharing some of the conversation I had with Hannah Hill from the National Association for Gun Rights on Friday, and really about what the next steps are, right? Because you've got the request for an emergency injunction that the U.S. Supreme Court essentially denied after Justice Amy Coney Barrett took the pleadings and the response from the state and put it to the whole court, and then the whole court on Thursday denied that emergency injunction. But Hill also talked about what the next steps are, and in particular, where we go from here with after the Seventh Circuit U.S. Court of Appeals denied an en banc review. What does this mean for the next deadline for the plaintiffs in this case to actually file a full writ of certs?
A lot of cases do get decided on the preliminary injunction, right? A lot of cases never actually make it to the going to discovery and going to trial and then summary judgment. Some of them do. We have two cases against assault weapons bans and magazine bans in Colorado that are going through that process now. But most cases, initially, you see the fireworks over the preliminary injunction side. And we've asked for that at the district court and got denied. The Seventh Circuit ruling I was just talking about was over the preliminary injunction. And, you know, lawyers may argue about what on the merits means, but the Supreme Court does take preliminary injunction cases. That's not considered emergency. That wouldn't be shadow docket. That would be an official appeal of the case. And it would be we would be asking them to overturn the Seventh Circuit's panel decision. So it's in a different category, a category that the court is willing to consider, unlike what we just filed, which was the appeal for an emergency stay, which goes on the shadow docket. They can step in and give relief if they want to do that. So our cert appeal is due 90 days from the denial of en banc review at the Seventh Circuit. 90 days, that's going to put us about in the second week of March. And obviously our lawyer is going to take the time to get it right, but we are anxious to file it as soon as possible. So definitely stay tuned for that.
So Hill talking about the next steps here and how 90 days from when the Seventh Circuit denied en banc, they can actually take the case back to the U.S. Supreme Court. So that's something to consider as we move forward. Of course, that still leaves that January 1st deadline in place, and that's something that has a lot of people seriously concerned because look at the calendar. Today is the 18th. Is that what today is? Yeah. So you've got next Monday is Christmas. And then the next Monday is January 1st. So that's the deadline to register firearms that the state has banned. Or if you get caught with those without registering, you could face a felony charge on the second offense. So here's Hannah talking about the January 1st deadline and how it seems that, at least from their case perspective, that's going to be in place.
It breaks my heart that they are facing it. That was why we asked for the Hail Mary move of an emergency appeal. We were hoping the Supreme Court would step in and take away that quandary. I will give the advice I always give, that is seek your own legal counsel on that question and make the decision that seems best to you. But definitely consult your own lawyer on that. And we can definitely help connect you with solid Second Amendment attorneys if anyone's interested and needs a recommendation on that. This is why our organization exists, is to keep these choices from being put before the people. But unfortunately, when state legislators are elected that routinely and deliberately trample on the people's rights, the court remedies are very slow and they're very uncertain, as we have seen. And I would encourage people to remember this at the ballot box and to mobilize and to get involved in holding the lawmakers who put this on them accountable for their decisions, regardless of what party they are. Vote gun rights when you go to the ballot box.
And again, this is Hannah Hill, the National Association for Gun Rights Executive Director, who's representing the Beavis plaintiffs out of Naperville that took their case to the U.S. Supreme Court. But last week, we heard Governor J.B. Pritzker talk about the lack of registry rules being finalized and how there's a lot of confusion out there. And he had this to say to that, and it's got a lot of people's attention as to whether the governor fully understands the law that he signed. Here's Governor J.B. Pritzker last week, and got Hannah's response to just some of the lack of understanding of definitions of sorts.
The reality is that most people really do understand these rules. And by the way, people are actually signing up, registering their automatic assault weapons, their high capacity magazines rather. And you know, as we get closer to it, we're seeing more and more people actually do what they're required to do under the law.
So Hannah said that it just seems to be more of the same of lawmakers wanting to, not necessarily understanding what the firearms they're looking to ban are.
So we know the whole thing is political, right? Assault weapon isn't actually a thing, right? They're basically they call it assault weapon because it's a scary term, and they're trying to win the battle for public opinion in the minds of the judges and everybody else. But an assault weapon is not an industry term. It's just a term for a gun that looks scary. So, and that's one of the things that we make in every single one of our lawsuits. Yeah, we sometimes have to use their shorthand, but we always do so with the footnote that, hey, we know, we need the court to know that the assault weapon is a politically charged term deliberately crafted to make these guns look bad unfairly. So that's the first thing. The second thing is that one thing we see across the board is that the people who are banning them rarely understand the basic mechanics of the guns and the magazines that they're banning. The more they talk about it, the more they betray a very woeful ignorance about the Second Amendment and about the actual arms that are in question. We see that on both the state level and the federal level. You can get a few real laughs sometimes listening to what congressmen say in some of these gun control hearings that they have from time to time on the Hill. And the final thing is, we see this is kind of the go-to. This is kind of the gold standard for blue states. When they want to trample the Second Amendment, what they really want is a ban on AR and AK style firearms, right? That's America's rifle. It's most Americans' number one choice for self-defense tools. And that's why it's so concerning that that's the number one thing that gun grabbers want to take away. And our argument is basically, if it's America's choice, you don't get to second guess that. You don't get to take that away. If it's in common use for lawful purposes, including self-defense, you can't take that away. And that's exactly what Heller said, and that's exactly what we're arguing in all of these cases. But at the same time, that is the gold standard for gun control. That's what Joe Biden has said over and over again that he wants. Every move that you see from the ATF, chipping away at the right to self-defense with, we're going to ban this accessory, and we're going to ban that accessory, that Congress, mind you, never banned. What they're going for is they're going for the semi-auto. With every step they take, every time they chip away at that right, what they're trying, the trajectory is to ultimately get an AR-15, AK-47 type rifle ban enacted by hook or crook, with or without Congress. And that's why it's so important to stop the ATF's depredations on our rights. And that's another thing that we're working on in the courts as well. But you see it at the state level also. I live in the state of Colorado, which is very sadly now a very, very blue state. And we just barely stopped a state level assault weapons ban from passing. We got a standard capacity magazine ban passed in 2013. We're fighting that in the courts now. But the legislature came that close to passing an assault weapons ban. We stopped it earlier this year, but it's going to be back, and we're going to have to keep fighting that. And as states turn blue, you're going to see that become more and more of a battle. And that's why it's so important for conservatives and gun rights supporters to keep control of their state legislatures and their local governments, because these pass at the local level as well. That is a very deliberate Lindbergh strategy. That's how our whole program started. It started by challenging 4 local assault weapons ban ordinances here in Colorado that were passed in response to basically a ground assault from these national anti-gun groups like Moms Demand Action and such as that, Every Town for Gun Control, Giffords. They were all agitating in this really liberal area of the state, and they got 4 different local governments to pass assault weapons bans. That's how it started. A lot of times as voters, we overlook the importance of our city council races and our county council races. The left does not do that. And if you want to hang on to your gun rights, we shouldn't do it either.
Again, that's Hannah Hill. She is the executive director for the National Association for Gun Rights, reacting to Thursday's news of the U.S. Supreme Court denying the preliminary injunction while the case plays out, saying that they are going to file directly to the U.S. Supreme Court by mid-March, if not earlier, a challenge. But obviously that does nothing for the January 1st deadline to register certain semi-automatic firearms, as you've got that deadline now 2 weeks away, and a lot of people questioning exactly how they're going to actually handle that situation. It is Bishop on Air. Be sure to like, subscribe, hit that notification bell. We will update you each and every weekday morning here on YouTube, X, and Facebook. Greatly appreciate you guys tuning in. All right, so a couple of other things that we got to tackle before we talk about what's happening in Chicago with the ongoing migrant crisis. We've got 2 different cases from Judge Stephen McGlynn that have been heard with oral arguments. One, if you recall, was the Thomas Mag case back in October. Well, we've got a decision in that one. The other one that was from the Federal Firearms Licensees of Illinois that was tackled in oral arguments last week. That's still pending. We'll get to that coming up here next. All right, it is Bishop on Air. I'm Greg Bishop. Thanks so much for tuning in. Be sure to like, subscribe, and follow along, and you can stay up to date with the latest of what's going on with the state's gun and magazine ban. And don't worry, I mean, there's tons of other stuff going on in Illinois that we have to cover as well. I think before the end of the year, I'm going to do what I can to unpack some of the 320 laws that are either partially or entirely going into effect on January 1st. So there's a lot to pour through there, and we'll do what we can to kind of break all that down for you. All right, so stay tuned. More coming up here with Bishop on Air. Different cases in the Southern District of Illinois. One has a ruling, the other we're still waiting on, and it deals with the state's gun and magazine ban and the registry that is set to take effect January 1st. That is 2 weeks from today on this December 18th. Greg Bishop with you. It's Bishop on Air. You can find me here each and every weekday morning. I want to thank everybody for tuning in. Like, subscribe, hit that notification bell, share it with your friends, and let them know that you tune in and why you tune in. Also, by the way, the contest we did have for people who shared on social media, I sent out some stuff. So those of you know who you are, you will be getting some stuff. And if you want to be sure to support the program, you can do that by going to my Bishop on Air store, where you can find a whole host of different products, including this product here, of a judge quote saying that the law is both stupid and very likely unconstitutional. That was concerning a law about crisis pregnancy centers possibly facing lawsuits if they didn't tell patients about abortions. So interesting quote there, but you can even get a teddy bear with, teddy bears are more regulated on it. So you can find different ways to support the program, including getting a whole bunch of swag with Bishop on Air on it. All right, so let's get to it because there's a lot of anticipation of what's going on. Of course, last week, you had Judge Stephen McGlynn. He heard the case from the Federal Firearms Licensees of Illinois, where you had the challenge of the state's registry. They were asking for that January 1st deadline to be suspended while the case plays out. And of course, that January 1st deadline rapidly approaching. But on Tuesday down in East St. Louis, the judge did hear oral arguments in that case where he said he was inclined to not issue that preliminary injunction against the January 1st deadline, but hadn't made his mind up. And he said that he was going to issue a ruling promptly. So you have that case that's still pending. And just to take a look at the docket here, you can see that on the 15th, which was Friday, the plaintiffs, they did file a motion to dismiss opposition filing. So essentially, I mean, this is a short little read here, but this is from the plaintiffs in this case, from the Federal Firearms Licensees of Illinois, essentially arguing that the state, their motion to dismiss is improper. They go on to spell out why this is the case. They say, to the extent the state argues the associational plaintiffs do not have standing on behalf of their members, plaintiffs contend that question was settled in Ezell versus Chicago. Plaintiffs, Gun Owners of America, and others have explained that the concerns and confusion they have heard from their members regarding registration, and it could not give definitive advice to their members due to the constant revisions and frequently edited guidance published by the state. That is sufficient to establish associational standing. So that's one of the plaintiffs, countering what the state said, that the state said that the plaintiffs had no standing because they're just an association. They have no standing. There's been no people who have actually been injured by this. But clearly, you've got the plaintiffs saying that their members are confused and they can't actually give their members any advice because of the constant revisions of frequently edited guidance provided by the state. The plaintiffs also went on to say that plaintiffs believe the arguments presented in their due process claims, even if not enough to earn a preliminary injunction, are clearly enough to state claims sufficient to survive a motion to dismiss. As the Illinois State Police continue to tinker with as yet unfinalized regulations governing numerous vague terms, plaintiffs believe it's important for gun-owning residents of Illinois to have proper notice, and the upcoming registration deadline could cause dramatic problems. The state has thus far not offered any extensions to the deadline, even as it's in Kafkaesque fashion will not adopt final regulations until after the deadline's passed. So that's what happened in the Federal Firearms Licensees of Illinois case on Friday. No ruling from Judge Stephen McGlynn on Friday in the FFL of Illinois case. The only thing Friday was a memorandum in opposition of the motion that the state filed to dismiss the plaintiff's motion. So we will be tracking this and see when Judge Stephen McGlynn's going to issue a ruling in the Federal Firearms Licensees of Illinois case looking to postpone that January 1st deadline. FFL of IL, they said that they're not looking to strike the entirety of the law. They're just really looking to delay that January 1st deadline. That's what they're looking for. But that wasn't the only case that's pending in the Southern District of Illinois. If you recall, back in October, the Langley plaintiffs in the Southern District, attorney Thomas Magg, these were all cases that were lumped together in the Southern District that went up to the 7th Circuit on the Second Amendment question, right? And for those of you who just now tuned in to this program, we've been tracking this step by step by step. And I do plan on, it's going to take a little extra work, but I do plan on trying to do a live to tape documentary of, the past year and how we've gotten to where we're at. So maybe I could try to do that as a live program sometime heading into the holidays. But regardless, you had the cases in the Southern District of Illinois all lumped together, a variety of them, Federal Firearms Licensees being one, State Rifle Association being another, National Shooting Sports Foundation. You've got the Langley plaintiffs with Thomas Magg representing them. So all these cases put together. Stephen McGlynn issued a preliminary injunction back in April, lasted 6 days before the states got a stay from the 7th Circuit, essentially saying that McGlynn's injunction is not in place. So that only lasted 6 days, where people called it, Freedom Week. But the 7th Circuit handling these consolidated cases. So Thomas Magg who actually filed the first case in this entire saga of cases. Filed it in state court, and then it got transferred to federal courts, and now in federal courts, made it all the way to the Seventh Circuit. But Mag took the vagueness arguments that he had, because he had a vagueness argument, he had a Fifth Amendment argument, and he had the Second Amendment argument. So all the lumped into cases that ultimately went to the Seventh Circuit were just dealing with the Second Amendment. But Thomas Mag brought out the vagueness argument and argued that in October. And if you missed that, you can check that out in some of my previous videos and reviews of all of this. So if you look at the docket for the Langley plaintiff's case here, we've been waiting for this, and I didn't mean to not check on Friday, but actually on Thursday, Judge Stephen McGlynn issued an order. And this is from the oral arguments that happened in October. So on Thursday, Judge Stephen McGlynn denied a motion for partial summary judgment. So the Langley plaintiffs were looking for partial summary judgment. They weren't looking for summary judgment of the entire law. They were looking for partial summary judgment on specific aspects of the law being too vague. Judge Stephen McGlynn on Thursday denied that partial summary judgment motion. Let's go ahead and take a look at some of what McGlynn wrote here in his 17-page opinion. All right, we'll go through this as best we can in the time that we have allotted here. But you've got the case again that was brought forward. Pending before the court is a motion for partial summary judgment on counts 4 and 6 filed by plaintiffs Jeremy Langley and others pursuant to Rule 56 of the Federal Rules of Civil Procedure. Defendant Brendan Kelly, the director of the Illinois State Police, filed a response, which the Langley plaintiffs filed a reply. Director Kelly filed an extensive motion to supplement his response, containing over 450 pages of deposition testimony and additional exhibits. The Langley plaintiffs filed a response to this supplement, having been fully informed of the issues presented. This court denies the Langley plaintiffs' motion for partial summary judgment, arguing that the Protect Illinois Communities Act is facially unconstitutional on vagueness grounds. So that was the argument that the Langley plaintiffs were making, that it was facially unconstitutional because it's too vague. Then goes through the relevant factual and procedural background as to how this case got to where it's at, kind of spelled some of that out for you. Then the Langley plaintiffs filing that motion for summary judgment back in May. Notably, neither the Barnett plaintiffs nor any of the other plaintiffs in the other two cases joined the instant motion. The pending motion concerns 2 counts in the Langley plaintiffs' original complaint, specifically those alleging the specific provisions of statutes in question are unconstitutionally vague. Conversely, Director Kelly argues that the statute is not unconstitutionally vague, that the Langley plaintiffs failed to meet their burden under the rigorous standard required for a facial challenge of unconstitutionality, and that even if the challenge portions were ruled unconstitutional, those provisions should be severed from the whole because of the Illinois state statutes of statutes. Oral arguments, as we covered, happened October 11th, and if you missed the oral arguments tweets, you can find those if you go back to my X page, or you can even just go and look at some of the YouTube videos from this channel around that time. So it then goes into the applicable law and legal standards, and again, this is the Langley case, not the Federal Firearms Licensees of Illinois case. We're still waiting on the Federal Firearms Licensees of Illinois case that Judge Stephen McGlynn did say he's inclined to not to give an injunction on, but he said he hadn't made his mind up yet. So we'll see what the Federal Firearms Licensees of Illinois case ultimately means. But when it comes to the Langley case that attorney Thomas Mag argued back in October, that has been denied, and that's what we're looking at here. So I want to go through and just read some of the final parts here. As you look at the 17-page document, the Langley plaintiffs argue that the Act's 10-round capacity restrictions for rifle magazines and 15-round restrictions for pistol magazines is ambiguous because there exist some pistols and rifles that use identical magazines. The Langley plaintiffs specifically cite the 9mm Beretta M992 pistol and the Beretta CX4 carbine as examples. They also argue that such weapons with interchangeable magazines are ubiquitous. Additionally, the Langley plaintiffs provide numerous examples of weapons that they argue do not fit the AR or AK category, which they claim infuses impermissible vagueness into the statute. In their oral arguments, the Langley plaintiffs argued that it was impossible to determine exactly what an AR-type weapon ceases to be an AR-type weapon for purpose of sale. In other words, a person of average intelligence and experience would be wholly unable to determine which feature must be eliminated or altered in order to render an otherwise impermissible AR-15 legal under the statute. Judge McGlynn also writes that the Langley plaintiffs rely heavily on some case law, where it's Springfield Armory versus the City of Columbus. They then analyze some of that case law. But I do want to just get to some of the other major parts here, where you've got the judge, Stephen McGlynn, talking about the U.S. Supreme Court repeatedly holding that imposing an intent requirement on an otherwise vague statute could save a law from finding an impermissible vagueness. Goes on to say that you've got some of the other case law review that the judge is doing here. Thus, while not dispositive, the presence of a cincture or mens rea requirement, it parries the primary thrust of a vagueness challenge. PICA contains one of the 4 explicit model penal code mental states, knowingly. The Langley plaintiffs argue that PICA criminalizes mere possession of prohibited items and points to Staples versus United States as established the mens rea requirement that applies here. Mens rea is like the intent. And that's, did you intend to violate the law? This may be so, but their argument does not negate the fact that unlike the National Firearms Act at issue in Staples, PICA does contain an explicit mens rea requirement that requires the government to prove that the accused knowingly possessed a prohibited firearm or ammunition feeding device. This also surmounts the hurdle discussed in the People's Rights Organization, in that the mens rea requirements in PICA is more than mere knowledge that certain magazines exist. Goes on to say that Director Kelly argues that the mere existence of a small number of interchangeable magazines does not leave the public hopelessly incapable of discerning what the act requires. He asserts that the number of off-the-shelf weapons with interchangeable magazines is much smaller than what the Langley plaintiffs claim, and that their claims are exaggerated and irrelevant. Kelly also argues that the definition at issue is not that of AR type or AK type, but that of a, quote, assault weapon more generally. Additionally, Director Kelly argues that ISP's duty to publish an annual list of prohibited firearms further clarifies which weapons are proscribed. And again, that's something that state police do each and every October 1st, is they can file new rules essentially spelling out what is and what is not banned. And again, what we're looking at here is the Langley case, not the Federal Firearms Licensees of Illinois case. That case still pending. Haven't seen Judge Stephen McGlynn issue a ruling there. But the Langley case that was heard on vagueness grounds back in October, we did get a motion to deny or an order to deny the motion for partial summary judgment. And that's what we're reading here is the filing from Judge Stephen McGlynn that was filed Thursday. Goes on to say, finally, he argues, and this is what McGlynn is saying, that Illinois State Police Director Brendan Kelly argues that the Langley plaintiff's use of hypotheticals is forbidden in a facial challenge for vagueness, stating that concocting a scenario where any uncertainty about the 10 versus 15 round threshold could arise requires plaintiffs to speculate about hypothetical or imaginary cases, which is not appropriate for a facial challenge. Then they cite some case law. McGlynn goes on to write that the Supreme Court has been clear that the holdings squarely contradict the theory that a vague provision is constitutional merely because there is some conduct that clearly falls within the provision's grasps. Thus, the fact that the statute has some valid provisions is not sufficient to defeat a facial challenge on vagueness. With this in mind, to survive this pre-enforcement facial challenge, the defendants must only demonstrate that the statute has a discernible core. With the enforcement of a statute will inevitably present many uncertainties at the margins, the Seventh Circuit has said that the resolution of those edge questions arises from the enforcement of a state law in a principal role of the state's courts. Goes on to say that you've got plaintiffs that they want to deem the law vague by identifying situations in which state officials might take an untenable broad reading of the language and then predicting that they will do so. It is far preferable, however, and more respectful of our judicial colleagues to assume that they will act sensibly and resolve the open questions in a way that honors candidates' rights under the First Amendment. And that was a quote from some other case law. It goes on to say that the fact that there exist pistols and rifles with interchangeable magazines does not mortally wound PICA. Rather, this is clearly a so-called edge question. The fact that the Langley plaintiffs' experts indicates that 6 of the 43 AR-type weapons explicitly cited in the statute are not substantially similar to the AR-15 is not by itself enough to make the statute unconstitutionally vague. Again, this is another edge question. The Langley plaintiffs' own experts demonstrated depositions that they understood there to be a discernible core to PICA and that they could advise their customers on which magazines were PICA compliant. Thus, the matter of enforcement is better addressed in an as-applied challenge. So really what I think I'm taking away from this is that you've got Judge Stephen McGlynn making it clear the difference between facial challenge, which just says, hey, before this, we're challenging it because it's unconstitutionally vague. He's denied the motion for partial summary judgment on vagueness grounds. So denying that in the Langley case and seeming to highlight that, well, it's going to be the as applied that's really going to be the crux here to address all of this. So it goes on to say McGlynn's order on the Langley case filed on Thursday. Moreover, the Langley plaintiffs asserted at oral arguments that the Illinois legislature could make the spring from a ballpoint pen illegal because it's nearly identical to the spring of the AR-15 buffer. Nowhere in PICA are springs or screws or bolts, for that matter, criminalized. While the tactic of absurd reduction may be more appropriate for an as-applied challenge for vagueness, this type of hypothetical or imaginary cases is inadequate and insufficient to the instant facial challenge of vagueness grounds. Therefore, the Langley plaintiffs' facial challenge has not met constitutional muster. Because of the inadequacy of their challenge, this court does not reach the question of severability and whether or not the Illinois statute of statutes will save valid portions of PICA. For this reason set forth, the court denies the Langley plaintiffs' motion for partial summary judgment, and they have failed to meet their burden to prove the specified provisions of PICA text unconstitutional because of facial vagueness. There are a number of outstanding legal challenges to various parts of PICA and the larger statutory scheme, but by this order, the court does not address any arguments suggesting that there may be other viable challenges to PICA, to the ISP enforced registration requirement, or to any other part of the statutory scheme included on an as-applied basis or under any other constitutional basis. So again, that was issued by Judge Stephen McGlynn on December 14th. So that was Thursday. So we're still waiting on the Federal Firearms Licensees of Illinois case to be determined. They're asking for that delay in the January 1st deadline, and whether or not that actually happens, we shall see. We'll be watching that closely because Judge Stephen McGlynn with the FFL of IL case said he would issue a ruling promptly. Have yet to see that. And will it come out before Christmas? That's the anticipation. Could it come out today? We shall see. But you saw the Langley case. We just went through some of the things that the judge laid out in his opinion, denying a motion for partial summary judgment against the state's gun and magazine ban. So that was against the ban, right? That was against the ban, Langley case. The much more narrow case seeking a preliminary injunction or a temporary injunction, that's what's still pending in front of Judge Stephen McGlynn from the Federal Firearms Licensees of Illinois. Hopefully you're not super confused. We will break this down some more as the things progress, but As it stands right now, that January 1st deadline is still very much in place. So we'll keep you posted on more as all of this plays out. It is Bishop on Air. Thanks so much for hanging out. You can find me anywhere. Just search Bishop on Air on X, on Twitter. Same thing, Facebook, YouTube, like, subscribe, hit that notification bell, and be sure to follow along there, all right? It is Bishop on Air. Thank you so much for hanging out, and we've got just another segment to do, so stay tuned. We'll get to that next here with Bishop on Air. All right, let's talk about what's going on in the city of Chicago. You've got the ongoing crisis of non-citizens arriving by bus, and last week we saw that the City Council of Chicago passed an ordinance allowing them to impound buses. Well, how is that working out? Headline from the Chicago Tribune is essentially saying that they've lost communication with these bus companies after that. What about the citizens and their ability to let Chicago City Council know where they stand on the city's sanctuary state and sanctuary city status? And what about the ongoing issues of crime? These things and more, I chatted with Chicago reporter William Kelly earlier this morning, and we talk about the voice of the residents being lost in all of this. And the backfiring of the bus impounding ordinance and more. Here's reporter William Kelly.
That's right, Greg. All of the above. You can't make this stuff up. And why would you want to? It sadly shows that our elected officials are a dangerous combination of incompetent and or corrupt. And they're not allowing me, anyway, to ask any questions about it. You know, we started off with this $29 million tent city that was absurd on its face. To put anyone in a tent in the middle of a winter, Chicago winter, was obviously absurd. But then we find out it's on top of a toxic waste dump. And still to this day, we're not allowed to ask questions. But that's a one-day story. Why? Because now we're faced with the chaos of suing bus companies, and surprise, surprise, the unintended consequence of that is the bus companies are just simply letting people off the bus at undisclosed locations. So now we have migrants wandering around. And guess what, Greg? Here's the new layer for you. Infectious disease. We have an outbreak of infectious diseases in the city of Chicago. Some people would say, well, what exactly does that mean? Why would you even say that? That sounds so rude for you to even say. Well, how does 400 cases of chickenpox sound to you? Have you ever? Do you know anyone who's had adult chickenpox? It's not pretty, and it has serious consequences. And it's being reported that a young child, I believe a 5-year-old boy, we're just investigating this now. This is just breaking now, I suppose. Died of a mystery illness at one of the largest migrant shelters in Chicago. Now, I remember not too long ago that our governor was saying that citizens needed to be vaccinated, whether they wanted to be or not. And now we have migrants just being let out of buses, wandering the city, and an infectious disease outbreak. Will our governor contact trace these migrants, find out what schools they've been going to, who they've been in contact with? And if not, why not? Why wouldn't he want to do that? He thought it was a perfectly good idea to contact trace your grandmother from Thanksgiving dinner. not too long ago. Remember, Greg?
Again, William Kelly chatted with him earlier this morning, talking about the sanctuary city status now, where you've got the citizens that were denied their ability to tell Chicago City Council through an official vote how they feel about that status. Where's that at in all of this?
Well, once again, here you have the Chicago City Council denying the people of the city of Chicago to vote on a non-binding referendum. By the way, anyone who tells you that the city of Chicago is somehow a functioning democracy or even a participating in a free country or something like this, you really have to maybe break that down for them. What we're really dealing with here. No, the majority of aldermen in the Chicago City Council voted overwhelmingly down on allowing the people of Chicago to even have their voices heard. This is alarming. We've had elected officials in the city of Chicago, the state of Illinois, tell us that all of the great institutions, the values, the morals, the values that built our country are all racist and bad, and the statues need to be torn down and the schools need to be renamed. But yet they seem to be promoting anti-morals or values that prevent citizens from even having a voice in the city of Chicago, Greg.
So again, you got a variety of different things going on with the ongoing crisis of non-citizens arriving to the city, from the bus companies being targeted and so on, and the lack of voice from Chicago citizens being able to tell their officials whether or not they want the city to remain a sanctuary city. But what about citizen safety? You hear about crime, and it continues. You've got the January 1st deadline coming to possibly, have people register firearms. I know Chicago's had a ban on certain types of firearms for quite some time, but William Kelly, how does this play out for citizens?
Well, Greg, it's a good news, bad news story in the city of Chicago when it comes to out of control violent crime. We have a governor who has and a mayor who have set the scene where we have violent repeat offenders back out on the street committing the exact same crimes that they were just arrested for, in some cases hours before. They don't have FOID cards, they don't have concealed carry, but yet they always have a gun. And our governor is telling us that gun owners, who by all accounts haven't broken any law in their entire lives, need to somehow curtail their rights. But yet we have a situation in the city of Chicago where carjackings, armed robberies, 14, 15-year-old children jumping out of stolen cars with long guns, completely defenseless citizens being robbed, raped. One case in particular, a one-man crime spree is what it's being referred to in the South Loop. A man entered a condo building, typically considered a safe place to live, raped a woman, and then robbed two or three other people, stole their car keys, and carjacked and stole their car. If one of them had a gun, obviously all of that could have been prevented. So there really is a real disconnect between the rights of criminals to apparently be released out onto the street where they always seem to have a gun, and the rights of law-abiding citizens to defend themselves. There was one story, Greg, though. This is the feel-good story of the week for you. A woman, it's being reported, wrestled a man with a machine gun to the ground and held him there until the police arrived. I don't know if the police arrived within minutes or hours. I don't know how long she had to hold this man on the ground. But it is possible, Greg, that even if our elected officials do disarm the law-abiding citizens, it is possible for women to learn how to fight men with machine guns, Greg. It is possible.
So again, William Kelly, Chicago reporter. We're not going to talk with him next week. It's Christmas, or January 1st. Of course, that's the new year. But what's the top story of Chicago? I asked him this morning.
Well, the top story out of Chicago, sadly, is the
for the year
incompetent corrupt elected official crisis that we're facing. As a life, as a reporter, it clearly is the root of all of these problems. As a lifelong Chicagoan, as someone who loves Chicago and loves Illinois and loves people and loves law and order, it is heartbreaking to watch it escalate on a not only a daily basis, a weekly basis, a moment-to-moment basis in the city of Chicago, Greg.
Again, William Kelly, always enjoy getting his perspective from on the ground and chatting with him earlier this morning. It is Bishop on Air. I want to thank everybody for tuning in. And, of course, we'll be back at it tomorrow. So greatly appreciate you guys each and every weekday morning as we try to break down some of the latest for you here with Bishop on Air. Again, if you want to support the program, you can do so by, of course, telling your friends and family about the program. You can also check out the store. Just go to bishoponair.com, and you can find some T-shirts there. People making suggestions of what kinds of T-shirts we should make up next. I gotta, be fair when we're making up some T-shirts, guys, so just keep that in mind. But I do appreciate all of the suggestions and all the emails, and if you want to reach out to me by email, I get a ton of them, and it kind of blows me away as to how much you guys do reach out. Greatly appreciate that. And if you want to email me, you can do so. Just email bishoponair@gmail.com. Again, bishoponair@gmail.com. Listen, tons of chat as well. People joining on X. It's good to see that. Randall, Steve, ABW, Warsaw Patriot, Zhang, Trevor. Some of you guys have been here for the long haul, so I greatly appreciate it. And more, John, Alfonso, Rob. This is great to see all you guys pouring in here and commenting each and every morning. Ed, thanks for being here. Neek, that's a Neek name, Neek. Yep. All right, guys, have yourselves a wonderful rest of the day. I got to get out of here, okay? Get back to work.
So